Hello everyone, I'm Raman here from BDO India. I handle indirect taxes including GST and customs. I have with me my colleague partner Sohrab Bararia, who's based out of Kolkata. Hello Sohrab.
Hello, Raman.
The two of us are here to have a discussion on Sabka Vishwas, the legacy dispute resolution scheme that has been submitted as a part of the finance bill, which is also has been passed in the Rajya Sabha and awaiting presidential assent. So once again, hello everyone. Moving on with the scheme, the amnesty scheme, the Sabka Vishwas legacy dispute resolution scheme. Let's call it as amnesty scheme for the purpose of convenience, has been introduced with the thought and the intent so as to reduce the huge amount of pending litigations, especially pertaining to two erstwhile legacy laws, namely the central excise laws as well as the service tax laws, as well as few other allied and ancillary laws that were imposed as a part of these two laws. So this in essence is the spirit of the Sabka Vishwas scheme to reduce the pendency of the litigation. Litigations which are pending right from the Assistant Commissioner, Deputy Commissioner level, right up to the Honorable Supreme Court level are included as a part of this scheme. One can, anybody who is a person who can file who can be a declarant as a part of the scheme can opt for the scheme. That takes us to the question: who can file under the scheme in terms of the dispute resolution? Saurabh?
Thanks, Raman. Hello, everyone. So, rightly pointed out by Raman, it's a cheer time for India INC. There has been the first time it has been enacted at a central level, a legacy dispute resolution scheme. While we did have a VCES for service tax in the prior some years ago, but now we have it for central excise and service tax laws and allied laws under these two laws. So going back to the question which you posed, Raman, person typically is defined under the Indian income tax laws, and that definition has been stemmed and used in various acts over the years. Here also, as part of this scheme, they have come out with an inclusive definition of person, and right from an individual to an HUF to a body of individuals to LLPs to partnership firms and corporates, even artificial juridical persons have been defined as persons. Now, person is the one who's making the declaration or is the declarant as part of the legacy dispute scheme. What would be important on what would he declare? So the next question which comes up to my mind is tax dues. Tax dues is something on which tax needs to be paid under the erstwhile indirect tax laws. So what they have done as part of this scheme, they have introduced a particular provision which talks about tax dues, and this ranges for orders which are pending dispute at various appellate forums. These orders could be in the nature of order in originals or order in appeals which are pending as on 30th of June 2019. Show cause notices which are pending adjudication issued before 30th of June 2019 where the amount of tax payable has been clearly quantified. Audit investigations and inquiries which have been initiated and are pending as on 30th June 2019 with a clear demarcation of the tax liability is part of tax dues. Apart from this, you can suo motu declare as your tax dues and go and file an application under the legacy dispute scheme. As part of your suo motu declaration, you need to state the admitted tax and the tax payable on that amount. Last but not the least, they have also covered the amount in arrears. This amount in arrears basically stems for orders in originals or orders in appeal for which no appeal has been filed. So an order which has been issued by the adjudicating authority and no appeal has been filed before the timeline for filing that order, that comes as an arrear of tax amount. Next would be admitted tax liabilities for returns filed under the previous indirect tax enactments, which is being admitted but not paid till date. Last but not the least, all those orders which have attained finality have been covered as part of tax dues and can now be covered under the legacy dispute scheme. So Raman, we did talk about tax dues and we spoke about amount in arrears. What is the scheme all about? The scheme is all about relief, right? So what do you think from a relief measure would be the application as part of this scheme?
Okay, so as the very nomenclature goes, it's Vishwas, and let's try to understand where the Vishwas comes from. Different kinds of buckets have been provided in terms of the relief a person would be entitled for. Let's call the person as a declarant from now. Now, the first one is basically what is the direct fiscal benefits that a person is, monetary benefit a person is going to get. It is bucketed in terms of where the tax dues are less than 50 lakhs, Sohrab. The person gets a tax relief of 70% of the entire disputed money. So, to give by way of an illustration, if there is 100 rupee which is a tax dispute, India Inc. needs to pay just 30 rupees and walk away from the dispute. That's the extent of relief that's being offered by the Amnesty scheme for matters pending below 50 lakhs. As regards the tax disputes of more than 50 lakhs, a person is mandated to pay 50% of the tax disputed amount and walk away from the dispute per se. Now, different parameters ranging from 40% relief to 70% relief has been provided, Sohrab, as a part of it. Now, is tax due the only relief? Not really, not necessarily. The relief also extends to that of penalty. Now, while the amnesty scheme bill per se doesn't talk anything about waiver of the entire penalty per se, one of the illustrations which is given as a part of the bill itself waives penalty to the extent of 100% when only penalty is involved where the tax has been discharged. Therefore, remains to be seen, going by the illustration that has already been given, we need to see whether this as a concept is going to hold good when rules are framed. That's one part of it. And second part of it, and equally critical, would be, when something starts as a dispute, Sohrab, the biggest threat is when does the dispute gets closed? Until the dispute gets closed, either it's just dropped or it needs to be owned up and paid, the biggest challenge is going to be the payment of interest. While the amnesty scheme per se doesn't set out anything specifically about interest liability, it's reasonable to, reasonable to conclude that when there is an expectation that out of 100 rupee, only 30 rupees needs to be paid if the matter is under 50 lakhs in the example which we took, reasonable to say that both penalty and interest would be waived. And this forms the crux of what the relief is. Of course, there are other beneficial relief, like let's say once the dispute resolution is closed, we can technically treat the entire matter as closed, knock it off from our pendency list itself. And imagine, Sohrab, the extent to which both India Inc. as well as the government authorities, as well as the benefits which is going to accrue to the judiciary, by removing all these as pending litigations, we will be able to breathe easy and step forward into the GST world with much more easier thought. And I also need to talk, while talking about the relief, I also have to add this. This relief does not necessarily mean that I'm going to go and confess to something for the purpose of getting the tax relief. There, right now at this point of time, the way the scheme goes, I'm not really going to talk about the merits of the case at all before the dispute resolution scheme process or even the designated authority. I just submit a paper for the purpose of closure of a case, which means the merits of the case is still intact if the merits of the case is going to impact or has impacted my functioning from a GST world, Sohrab.
Agreed, Raman. I completely agree with you on that. So Raman did clarify that the range is 40 to 70 for slabs above 50 lakhs and for slabs below 50 lakhs. One another interesting proposition is the fact that pre-deposits would be adjusted against your final tax dues. So by adjustment of pre-deposit, what would happen is at various stages you have gone through a procedure of stay. So it could range from a 7.5 to 10% under the erstwhile legacy indirect tax laws. It could be on the higher side also for cases which are there in the past periods. So in those cases, all these pre-deposits would be adjusted against your final tax dues. Now that is what the bill envisages. What it does not envisage, Raman, and that's a double whammy, is the fact that in a situation where your pre-deposit exceeds your tax dues, so let's take a typical example of rupees 100 being a tax liability, and you get a relief of, let's say, 70%, and 30 rupees is all you need to pay, and you have paid a pre-deposit of, let's say, 45 rupees. Those additional 15 rupees will not be eligible for a refund to you. So what are your thoughts on that, Raman? Do you think that the scheme has come out truly in terms of its intent of not refunding you the pre-deposit?
Okay. Okay, so Sohrab, let me put it across like this. We were talking about a situation where in the legacy laws where charging a pre-deposit or asking an applicant to pay a pre-deposit was basically the prerogative. Now, if you look at it post the law, where it says 7.5% would be the pre-deposit, I don't think we're really going to have a situation where the tax dispute is going to be less than 7.5% unless it's an exceptional case, and let's not talk about the way to exceptional cases. Going back to your question, some of the tribunal benches did impose as a matter of prerogative a pre-deposit of 40%, 50%. We also need, India Inc. needs to do a quick cost benefit analysis based on merits of the case. If one is to say that we have strong merits, prima facie merits of the case, then the larger question is why was a pre-deposit at all, levied, rather than giving a clean and clear stay without a pre-deposit involved. And that's what takes us to the next concept. Sohrab, how do I approach making use of the amnesty scheme? Number one, I need to do a litigation mapping. India Incorporation needs to do a litigation mapping. We need to knock off, as a part of the indirect taxes, we need to knock off the cases pertaining to customs, the cases pertaining to VAT, CST, which is all not covered as a part of the amnesty scheme. We also need to knock off the cases which pertains to refund, which is not again covered as a part of amnesty scheme. When that leaves me with the bulk of the rest of the cases, the India Incorporation needs to understand how much of the merits they have in terms of the cases involved, namely in terms of probable, possible, and remote assessment based approach. Now, one can even stretch this by saying if a high court is expected to have a monetary limit for the purpose of accepting cases either from me or from the department, we can argue that if the monetary limit is not adhered to it, I can request on the basis why should I go through amnesty scheme at all. It depends on the whole idea of going before amnesty scheme is to reduce pendency of the litigation, but it's not to take all my pending litigations before the amnesty scheme as well, Sohrab. Does this answer your question, Sohrab?
Yeah, absolutely, Raman, and completely appreciate that. So rightly said, we need to assess the matter on case-to-case basis. Having said that, there are few more contours as to the scheme. One important part would be in terms of cases under which a person is convicted or is pending prosecution. Those are the kind of cases where relief would not be available. Typically for refund matters under your erstwhile service tax laws and central excise laws would not be covered as part of this amnesty scheme. Cases where you have actually admitted your liability and not paid your liability is where you need to pay the full amount, so there is no relief per se in such matters. There are more situations here. One such situation could be, you have gone in for an appeal and the final hearing has been concluded. Such matters are not covered under the amnesty scheme. So India INC needs to take a thorough revisit of their existing litigations and map them as per the various contours provided under tax dues and amount in arrears to actually come out with the relief which they want to go under this scheme. Now, Raman, one more thing which I wanted to ask you, and it comes, interestingly, under the erstwhile VAT and CST laws, you would see amnesty schemes very frequently in the states. Those amnesty schemes had something interesting. They had, pre-deposits, they had installment systems, they had a chance, they gave you moratoriums also. Do you envisage any payments by installment here under this scheme?
Okay, that's a very interesting question, Sohrab. Number one, the various kind of amnesty schemes which we have seen, either offered by the union or by the different states, were essentially to clear certain amount of pendencies. We are talking about the dispute resolution scheme which is proposed, which is to be implemented to very clearly to clear up the pending backlogs pertaining to two major legislations that have since been repealed. Having said that, we also need to understand that when there is an expectation to pay 30 rupees out of the tax dispute of 100 rupees, we need to really wait and watch whether installment kind of a scheme is really going to come up for the remaining part of 30 rupees also, Sohrab.
Completely appreciate that, Raman, and that is something which we need to wait and watch when the fine print comes out as part of the official gazette. As far as procedures are concerned, as far as window for filing, as far as how the application needs to be filed, where you need to file the application, then the various forms and the various stages, the designated committee which will actually go through your application, scrutinize them, issue you a discharge certificate. All these are part of procedures, and those procedures would be framed in terms of rules. So that's a wait and watch for India and see how the rules actually come out. The biggest relief, I believe, which has been given in this scheme as of date is it is not only for pending litigation, is also suo moto for cases where you want to go and admit a liability. Raman, what are your closing thoughts before we conclude on the benefits of this scheme?
It's extremely beneficial. The amnesty scheme, I would say, provides a very good advantage, a very good platform for India Inc. that is in many ways overloaded with pending litigations. While we might think that it is good to wait and watch, it is of equal importance because over a period of time, as time passes by, for people to rely upon cases in the world of central excise and service tax is going to become a rarity, and therefore a quick closure is always a good closure. And let's have closure by opting for amnesty scheme wherever it suits us. Having said that, the relief that has been provided is also quite high, and that gives me a very good choice as to whether I should retain the pendency of litigation or whether I should go for a quick closure, Sohrab.
Well said, Raman. I think I completely agree to that point that, India INC should rejoice and should celebrate the fact that a scheme has come in the central laws. My thoughts to, as to the closure of this discussion would be map your litigations well, understand the procedures, and once the rules come out, map it with the existing laws and the forms. See cases where you have a strong chance of winning, because central laws are pro towards the assessee, and there could be favorable judgments. Go through that. Once you decide on that, file an application ASAP under this scheme, because this scheme would have a limited time frame and a limited period for closure. Last but not the least, the scheme will also help you to shed the excess baggage in your books of accounts in terms of contingent liabilities. Thank you so much, Raman. This is Raman and Sohrab signing off. We hope that you understood the scheme well, and we hope that you really liked the talk show. Thank you.
Thanks everyone for watching myself and Sohrab, and we would be more than delighted to support you in case if you have any further queries to us. do not hesitate to contact us. Thank
Thank
you
you.
and bye bye.
Bye bye.